by courts, including high courts, trial courts across India, consumer forums, departmental inquiries, and trial court martial cases across India. Sir has presented research papers in various national and international conferences related to forensics and law, and has been invited to deliver lectures in various institutions, law departments of several universities, Karnataka Police Academy, and various bar associations all across India. Sir has spoken on several topics, including the forensics and criminal investigations, cross-examination techniques, documentary and digital evidences, lie detection, and interrogation techniques. It's an honor to have you, sir, and I welcome you today. Now, I would like to request Professor Dr. N.K. Behel, sir, to come and take over, please.
Thank you, Shabhavi.
Thank you, sir.
Honorable the Chairman, JIMS Group, Dr. Amit Gupta ji, Campus Director, Dr. R.K. Raghuvanshi sir, Principal, JEMTEC School of Law, Greater Noida, Professor Dr. Pallavi Gupta ma'am, Professor Dr. A.K. Tyagi sir, all the HODs present over here, my faculty coordinators, Shri Sudhir Dwivedi sir, Shri Rahul Arora sir, and Nirav Khare sir from JEMTEC School of Law, students coordinators, dear Shivam Tiwari, Saurabh Gua, and moderator and anchor of the day, my dear Shambhavi Srivastava, dear faculty members and students. I, Dr. N.K. Behel, Professor of Law at JEMTEC School of Law, Greater Noida, District Gautam Budh Nagar, UP, on behalf of JEMTEC family and on my own behalf, heartily welcome Honorable Shri Fanindar B.N. Sir, who is a Director of Clue 4 Evidence Forensic Investigation Private Limited to JEMTEC School of Law. Sir, it's my privilege to welcome you, and we are really delighted to welcome you, sir. Dear participants, as you have heard that Fanindar sir is an expert in the field of civil, criminal, and constitutional laws. Sir is dedicated to provide access to justice to the masses. Congratulations to you, sir, from JEMTEC family. At the same time, we are happy to know that Fanindar sir has a keen interest in academics, and he has contributed various articles which have been published in various journals and magazines. It's great that Fanindar sir has represented prosecution side also, and he knows how tough the burden of proof is. It may be preponderance of evidence in civil cases or beyond reasonable doubt in criminal cases. We once again welcome you, sir, to JEMTEC School of Law, Greater Noida, and we will invite you to our campus again once this pandemic of COVID-19 is over. We thank you so much for accepting our invitation, sir. Dear students, today's topic, 360-degree view of documentary evidence, is very interesting subject in today's contemporary digital world. You will be greatly benefited by today's deliberations. Dear students, when I was doing my LLB course at Dehradun, our teacher teaching us law of evidence gave an illustration in the class that a jet intruded from Pakistan airspace to Indian territory and went back leaving his white tail in the sky, which disappeared after 10 to 15 minutes. It was discussed that impression of white tail left for a few minutes was within the definition of a document or not. After due deliberations, it was concluded that white tail is not a matter expressed or described on any substance by means of letters, figures, or marks for the purposes of recording that matter. Hence, this white tail of jet was not within the definition of a document. I hope that Fanindar sir will throw some light on this also. Dear students, today You will definitely learn the niceties and intricacies of various dimensions of documentary evidence. All of us know the cardinal principles of evidence are that a document can be proved either by primary or by secondary evidence. But what about admissibility of electronic records like email, CD, DVD, pen drive, or other video recorded items produced by a computer? Which one is original, which one is primary, and which one is secondary evidence? Dear students, you will be confronted during your internship and practice on litigation side as to how to prove an email in the court of law, how to prove WhatsApp messages in a court of law, how to prove CD, DVD, or video recorded material in the court of law. I'm keeping one illustration for the dear students, and I'll request Fanindar sir to throw some light on it also. Illustration is that a person recorded the incident of a bomb blast on his mobile phone and sent the video on WhatsApp to his friends in the group. Finally, this video reached on the mobile of investigation officer who was investigating the crime. He produced the video in the court of law for the purpose of proving the incident of bomb blast along with charge sheet. Will this video be admissible in evidence? Who will issue certificate required under section 65B of Indian Evidence Act? Dear students, Fanindar sir will explain you these situations according to time available at his disposal. Fanindar sir, our students and faculty members are very keen and eager to listen to you on today's interesting subject. Sir, you are once again welcome to the family of JIMS. Thank you for accepting our invitation. Over to moderator anchor, please. Shambhavi.
Yes, sir. Thank you so much. I would now request sir to please have no further delay and begin with the session.
Well, I would like to thank Professor Dr. Naresh Kumar sir for inviting me for this session, and all the coordinators who are in the session today who are putting efforts in making this event a success. It's a pleasure to address this topic because I believe this topic is one of the most criticized category of evidence before the court. Because when we say about the documents, documentary evidence, and especially one part of document being the handwriting and signature, are the most criticized category of evidence before the court, even today. So let us understand as to why it is the most criticized topic of discussion, and as legal professionals, how do we put forward the documentary evidences in the future course of action. So I would like to share my screen. Yes. Yes, participants, today we'll be discussing about the topic of discussion would be including handwriting and signatures. And we'll discuss about who is an expert, because while we're discussing about the documentary evidence, who is a document expert, or the legal dictionary meaning as to who is an expert, we'll discuss about it. We'll also discuss about forensics and case studies as per today's topic of discussion. Before I proceed, when we're discussing about the documentary evidence, I should definitely share this instance with you, where one of the Indian businessmen was invited by a US businessman for a get-together party in Washington. In fact, the businessman of US has hosted a get-together party, inviting all the businessmen across the world. While this party was going on, everybody who were present in that session happened to realize that this was the costliest party ever hosted by any businessman in the world. People were very curious to know how this person became so rich and so, organizing such a grand party. While the Indian businessman could not stop himself, he went and asked the US businessman, "Hey, how could you be so rich? How could you make such a lot of money?" To which the US businessman mentioned, "Get into my car." They both sat in the car. The car went for a long drive. The car stopped. They both got on the car, and the US businessman happened to show, "Hey, look at that flyover. Oh, it's good. It's good flyover. I had a tender to construct that flyover. However, 10% of the flyover cost unofficially made me so rich." Wow, it's a good idea. Few months later, the US businessman received an invitation in his hand, inviting the US businessman for a get-together party, this time in India. So when the US businessman came to India, he was not just surprised, but he was shocked. Oh my God, whatever the facilities he happened to arrange in Washington is nothing as compared to what he is seeing in India this time. And he is now attending the world's costliest party by a businessman in India. He could not stop himself because he went and asked the Indian businessman, "Hey, how could you be so rich? Because you are an Indian businessman and I earn 70 times costlier than Indian currency. But yet, if I could not host such a grand party, how could you, as an ordinary Indian businessman, can do this?" To which the Indian businessman said, "Get into my car." They both sat in the car. The car went for a long drive. The car stopped. Indian businessman is talking about the flyover, and he's searching where the flyover is. And Indian businessman says, "100% is mine unofficially," which means, as per the document, there exists a flyover, but reality-wise, it might not be anything. See, I just gave you a extreme situation of how the documents can be built in the litigation process. But however, this could be a flyover which I gave you as an example. But we talk about the properties, and we talk about the document papers. Yes, there are many such things which doesn't exist in reality, but it only exists as per the documents. So if such is the case, while court of law relies upon the documentary evidence, for the court of law, it needs to see the documents pertaining to your litigation or to your pleading. If such is the case, what kind of document can hold good and what kind of document can be questioned? If in case you want to question a document, what all things can be questioned? So this becomes a topic of interest for today. Before I proceed, dear participants, I want to understand what actually, what are the elements, different elements which makes a document. You can just unmute your microphone. Just let me know who want to answer this question as to what are all the elements of a document. Anybody want to volunteer and state this answer? I hope you are given the rights to unmute your microphone, or is it still controlled by the host? Can anyone confirm me on this?
Sir, it is controlled by host. They will ask question in last.
Okay, fine. Fine. Participants, you can also use the chat box to answer this question. So the question is, what are all the elements of a document? However, the various elements of documents includes, first of all, the documents will contain some kind of contents. Okay, so any kind of content which is on the paper becomes a document. So that is the content is the first part of the document. However, the content can be handwritten, typed, or printed. So the printer, typewriter, or the handwriting becomes the second element of the document. Third, the document will contain certain rubber stamps belonging to various authorities, which could include the authority who is giving the stamp paper, the treasury, and it could also include the stamp vendor, the deed writer, so sub-registrar, notary. So all these authorities will have the rubber stamp. So the document might contain a rubber stamp entry also. Next, the document, first of all, what we actually refer to document in the legal course is a piece of paper. So document also contains paper. The document contains ink. Whatever the content is there in the document, only because of various inks is what it is visible to us. So document contains ink. So there are various elements of document, and while I am discussing every list here, you need to understand every of this list can be questioned onto the legitimacy of the document. However, the procedure of the legal documentation is that all these entries must be present, but this the entries, how it is made on the document, be as acceptable in the same chronology of execution, which means first the document is to be typed, then it is to be signed, then it is to be registered, then it is to be notarized. See, I am giving you different scenarios how the documents are prepared. So all these entries are there, but it should be in the same chronological order. But suppose if there is a document and I have signed the document already, and after this a document is typed or printed, which also overlaps signature. So if in case I want to prove that my signature was taken on a blank paper and then it was developed later on, so yes, the content, how it was executed, the chronological difference will actually nullify the document's validity. Yet it depends on different legal provisions. We still have provisions under Negotiable Instruments Act, where if the document is signed partially or completely blank, okay, that means the person is giving the prima facie authority for the receiver to write whatever you want. Section 20 of Negotiable Instruments Act talks about this. However, our topic of discussion here is that there are many elements of a document, and every element has its own legal sanctity, and anything which actually is proved to be a fraudulent entry in a given document, the entire document loses its validity. That is the topic which we're discussing right now. While we are discussing about the first element of document, which is the handwriting or the signature for that matter, the signature and handwriting are the most disputed part of the document, because anybody feels if you have signed the document, you owe the document. But the moment I dispute my signature in the document validity is now questioned. So very frequently, the advocates only question the signatures in the given document and irrespective of any other content of the document. While this is a scenario, let me ask you the question as to what is a handwriting. What is handwriting, dear participants? You can use your chat box to answer this question. What is handwriting? One moment.
Participants, please use your chat box to answer the questions.
If the answer is that handwriting is the way a person writes, okay, but if I ask for the question as to why is it called as the handwriting? Why should we call it as a handwriting? The very frequent or most expected answer for this question is that because people use the hand to write, it is to be called as the handwriting, isn't it? However, have you seen people writing without the hands? Yes, in every examination season, the public level examination season, we get to see in the newspapers, people without the hand can still write. So in such case, while people here on the screen, if we had to believe that because people use their hand to write, it is to be called as a handwriting, what do you call this images as? We don't call this as the leg writing or the teeth writing, isn't it? Because it is still called as the handwriting. It is true that most of us use our hands to write. That is why it is generally called as the handwriting, but technically speaking, it is not your handwriting. It is your mind writing. The source of your writing is not the hand. It is your mind. Hand is just a medium to write it. People without the hand can still write, and technically they can still prove who wrote this. However, it is a limitation for a handwriting expert that we cannot say from which part of the body the writing has been written, because it is a mind writing. We can definitely identify who wrote this because it's a mind. The source of the writing is the mind. While, let me ask the question to all the students here. If I ask you the question, how many of you here can change your handwriting? Can you change your handwriting, dear participants?
Yes, sir.
I'm waiting for your answers on the chat box. Given a situation, can you change your handwriting?
Yes, so we can. I'm answering on their behalf.
Okay.
Yeah.
In such case, what do you think? Why do you think the court of law has to rely upon handwriting as a good piece of evidence? Given the reason that you can change your handwriting whenever you want it. So why do you think the court of law still relies upon your handwriting as a good piece of evidence? Nature and signature cannot be changed. Correct, sir. Yet, let us throw some light on this topic of discussion, because as students, every one of us will keep changing our handwriting purposefully, especially in our examination answer sheets. Because the moment the examination answer sheet is given to you, you are calm, peaceful, you want to try impressing the answers. So you start writing very neatly and very slowly. But when the first bell goes off, you get alerted, oh my God, I have a lot of things to write. So you start writing a bit faster than how you started your examination answer sheet. But while the examination papers are getting ended, but the last few sheets, you guys have a principle. Writing is my responsibility. Understanding is their responsibility. So we also adopt this principle in the examination answer sheet. But yet, how can one have so much of changes in the handwriting? If such is the scenario, why should the court of law should rely upon signature and handwriting as a good piece of evidence? That's the question which we are trying to answer at this discussion, dear participants. Fine. On the screen, you can see the image of the brain. However, the brain is a hardware and the mind is a software. We cannot see the mind. Mind is a function of the brain. Mind is classified into two categories, conscious mind and subconscious mind. It is not my theory, but it is the psychologist theory that subconscious mind is 90% stronger than your conscious mind. Which means whatever you do on a routine basis, you only do 10% consciously and 90% it becomes subconscious. Any activity which is done for 21 days continuously, dear participants, it becomes subconscious. Again, this is not my theory, it is a psychologist theory. Your handwriting is subconscious up to 90%. And why I am discussing about this theory is because while I discussed about the handwriting being mind writing, and mind is 90% subconscious, and yes, whatever you want to write today, and there is small variation here. Let us now do a small activity to understand if your handwriting is completely or partially conscious or subconscious. I want all the participants to use your writing material. I'm going to give you a small short paragraph as a dictation to understand if the writing is conscious or subconscious. If yes, we shall discuss about this further. Be ready with the material to write. Use a fresh sheet. Use a fresh sheet to write. Let me start with my dictation now. In indoor zoo, was a monkey. There was a monkey called Raju. there was a monkey called Raju. This monkey had the habit of throwing bananas at the people, coming to the zoo. Looking at this monkey, other two monkeys, Simple and Dimple, also started doing the same thing. Now, sign this document 3 times, dear participants. Put your signature 3 times. Put today's date and place also. All right. Now, using chat box, please tell me if the writing activity what you did was conscious or subconscious. What were you conscious about and what was subconscious in the whole activity? Yes, participants, I'm waiting for your inputs on this. Okay. How many of you believe?
Sir, I am getting the answer from the participants. And they are saying that the conscious part of the writing was knowing that you are dictating, and then the paragraph was the conscious part, and signing 3 times was partially subconscious part.
Okay. Participants, it's a fact that you are actually more conscious about the story what I am dictating you, where I'm introducing Raju, Simple and Dimple. That is not a serious story at all. You could have been thinking, where is this monkeys coming from? Simple, Dimple and Raju. You're conscious about the story, but not the style in which you are writing it. Because the writing, you have been practicing over a period of time by now. And because of that, the writing has become subconscious. And yet, while I discussed conscious mind is 10%. And yes, you are conscious about the writing part of it only in your activity. So for this reason, while the writing is 90% subconscious, the court of law has a reason to believe and rely upon the handwriting and signature as a good piece of evidence, because the subconscious, when I say subconscious, you need to understand the simple understanding about conscious and subconscious. Conscious mind is something which you think you are. You might not be that person, but still the way you consciously think and believe what you are is conscious, and whatever you are and what you don't know about yourself is subconscious. If I ask the people here, if anyone here can run faster than a dog, you would say, no, I cannot run faster than a dog. But it's a matter of fact that if the dog chased you, you are always ahead than the dog. It is an experience for everyone, at least for everyone, once or the otherwise in your entire life. At least one of the dog has chased you. While the dog has chased you, you were always ahead than the dog to a larger distance. You did not realize that, yes, I can run faster than a dog, at least for 200 meters. But when the situation demanded, you actually have done that. That is your subconsciousness. Yes, subconscious mind is something which you have and which you don't know about yourself is 90%. And whatever you think you are, which you might not be, is conscious mind, which is 10%. Writing is subconscious activity, which is 90%. And even if you want to change the writing style, you cannot change it because you don't know what style you have got in your writing. And yet, even if you want to change, you can only change up to 10%, which is conscious mind, and the 9 habits can never be changed. That is why court of law, even today, relies upon handwriting as a good piece of evidence against the people's belief that yes, I can change my handwriting. It is a myth. This statement is factually wrong because you cannot change your handwriting. When I say you cannot change your handwriting, I'm talking about the 90% subconscious writing habits and not the 10%. This 10% can include your size of the writing. You can try to change big writing to small writing, a slanted writing to a vertical slant writing, or vice versa, or connected to a block writing. So this is a few things which anybody can try to change it. But there are a lot of other factors, a lot of other characteristics which can never be changed is what the subconscious writing habits I'm talking about. While we have now just discussed about the fact that the writing definitely is subconscious, we are now touching upon the topic of the forensics. Today, while most of the TV serials, most of the serials, movies, Netflix series, I tried showing a lot of things about the forensics. You need to understand, forensics is a branch of science which deals with the legal investigation process. To be more precise, forensics is nothing but giving a logical justification of the conclusion. Definitely, logic should be supported by the scientific facts. So, when the explanation of forensics in the earlier textbooks was that forensics is a branch of science which deals with the legal investigation process, today we have also seen forensic audits, forensic accounting, forensic linguistics. See, accounting is a branch of commerce. Linguistics is a branch of arts. But today, we are discussing about forensic auditing, forensic accounting, forensic linguistics. So how does this subject of arts, subject of commerce comes into the branch of science? This becomes a question. However, science has a lot of branches in forensics. Forensics has a lot of significance in science subjects, physics, chemistry, toxicology, biology, zoology. Everything has a significance in science. But what happens in arts and commerce? For this reason, the term forensics is to be understood as a systematic process of examination. Systematic process, or the procedural aspect, which includes logical justification. Today, for all the banks, the nationalized banks, forensic accounting report is a compulsory factor. Forensic accounting being a commerce industry, still the forensic report has to be submitted for that, because the each and every paisa, where it is coming, where it is going, should be reported to the RBI. So for this reason, forensics is to be understood the way I am showing it to you on the screen right now. 4 and 6, 4 and 6, 4 plus 6 makes the value as number 10. Participants, 1, 0 makes the 10. In binary system, 1 is always given a truth value, 0 is always given a false value. The scope of forensics is to conclude if the claim is false or claim is truth. 1 as in truth, 0 as in false. So the claim can be brought in by any of the parties in the case. The parties in the case, I mean the investigation officer, the litigants, or even the court of law. These people, any of those people might raise any issue on any category of evidence which need to be forensically authenticated. So the authentication process will conclude if the claim is the truth claim or the false claim. I say this blood sample belongs to him only. After forensic examination, I do conclude, yes, this blood sample belongs to this person only. That is the truth value. I then say, no, this blood sample does not belong to the same person. That is a false false value. So the scope of 406 is to conclude if the given claim is truth or the given claim is false. This is how I would like to explain the term 406 in addition to all the hype what you can see in CBI, CSI serials. Participants, on the screen, you have got an image. I would like you to comment if line AE or the line EC, which of these two is lengthier? How many of you think the line EC is lengthier? Please raise your hands. People thinking that line EC is lengthier, please raise your hands. Okay, sir, thank you. How many of you participants now carefully listen to my question? How many of you think the line AE is lengthier? Raise your hands. Okay. Thank you. See, when I compared with my previous question, most of you think that line AE is lengthier than the line EC. Fine. Let me ask you one more activity to be done. I believe most of you are holding your mobile phone while you are looking at this screen. I would recommend keep your mobile phone away, okay, and take 3 steps back. Keep your phone away and take 3 steps back and open your arm like this straight. Focus on the black dot on the screen. Participants, get back from your screen. Open your arm, use your index finger and focus on the black dot. Close your left eye while you're focusing on the black dot. All right. Now, keep your hand straight. Keep your hand as it is. Open your left eye and close your right eye. Are you still focusing on the black dot? If you are still focusing on the black dot, let me know. Raise your hands. Are you still focusing on the black dot? Kushagra, you need to just move away from your screen and then do this activity once again. Open your arm straight, focus on the black dot, close your left eye, focus on the black dot. Open your left eye and close your right eye. Are you still focusing on the black dot? No. Because your eyes, you think your eyes is cheating on you. Because you think you are focusing on the left eye, but you are not actually focusing on the, sorry, you think you're focusing on the black dot, but you are not actually focusing on the black dot. Our eyes can cheat us. The scope of 406 is that the reality of 406 is that we have to start with our examination with the belief that our eyes can cheat us. That means we cannot conclude anything just by the way it appears. We have a good scope for examination. After the examination is what we can conclude the reality of the given case. However, to answer to the previous question, participants, line AE and line EC. Line EC is lengthier than the line AE. For people who are using this session on the computer screen, we can use to measure this by the scale to understand how big the line EE or the line AE is. Because on the mobile screen, because the image appears to be very small, you only see a small difference in the line AE and EC. Otherwise, the fact is that line EC is lengthier than the line AE, but given the fact that our eyes can cheat us, it appears that line AE is lengthier when compared to the line EC. Okay, but the scope of 406 is to go beyond what we see with our naked eye. We just establish a lot of facts behind our theories. While we are discussing about this, the question arises as to who is an expert, who is that competent person who can comment about the documentary evidence. In our legal system, dear participants, we have only very few sections which talks about the experts, out of which one is section 293 of CRPC. This talks about the experts. Section 45 of Indian Evidence Act that Indian Evidence Act is missing in the slide. Please make a note. Indian Evidence Act. Okay. Section 45A, again of Indian Evidence Act. Section 79A of Information Technology Act. These are the 4 specific sections which talks about the experts. One beautiful thing about section 293 CRPC is that this talks about certain reports of certain government forensic experts. And while you all, or even I also had a question before me, does our legal system or does our law limit the use of forensics? Because forensic examination, we give a lot of technical reports, a lot of justification to our sample examination and everything. But just because we have given such kind of report, should the court of law compulsorily rely upon our report? If that is the question, this 293 CRPC very clearly mentions that who is a government expert. The report given by government experts, any document purporting to be a report under the hand of a government scientific expert, to whom this section specifically applies for, upon any matter of thing duly submitted to him for examination or analysis and report in the course of any proceeding under this, may be used as an evidence in any inquiry, trial, or other proceedings under this code. You need to understand that this lawmakers have used the word may be used as an evidence, but it is not shall be used as an evidence. May be used is actually the scope or the prominence or the flexibility, discretion given to the honorable court. The court may consider the report of the forensic expert as evidence, or even keep the report aside if the report is not getting aligned with the other facts of the case. For which one of the beautiful case law, dear participants, you need to read this complete judgment, you need to understand the whole case, is the famous case of Dhananjay Chatterjee versus State of West Bengal. Please make a note, Dhananjay Chatterjee versus State of West Bengal. This is a beautiful case law or a unfortunate case law where the court of law kept the report of the forensic expert aside and had to rely upon the circumstances of the case. Let me just give you an outline of this case. The girl who was residing in an apartment was teased by the apartment security. She happened to complain to her father that he is doing this, and her father happened to report this to security officer, and the security guard was supposed to be transferred from the next day onwards. Next day was Thursday. This day, the same security guard reported to the same apartment. He did not report to any other apartment, but he still reported to the same apartment. At 2 o'clock, the girl comes back from the school after her exam. She had her lunch, she slept off. At 5 o'clock, the mother, usually on Thursdays, she should go to the temple. 5:15, she leaves home. It's just very, very close by to the temple. It just takes 20 minutes to come back, maximum 20 minutes. So she goes out, and when the mother goes out, the security guard tells another security guard, I have some work in the first floor, I'll go and come back. He goes to the first floor where this girl's residence is, and by next few minutes, the security officer comes to that premises, realizes that Dhananjay is still in the same apartment. He calls Dhananjay. Dhananjay peeps from the balcony. Oh, okay, sir, I'm coming. So he comes down and he does not speak anything to the security officer, but he rushes back to his home. When the mother comes back, the door is locked. The girl is not opening the door. People get panicked, and the door was broke open because of the reason the girl came from the exam, and there is a possibility she did not do well in the exam. She would have committed suicide, kind of a thing. So by the time the door was open, the girl was lying in the pool of blood. And suddenly doctor comes and doctor declares the girl dead. Now, Dhananjay Chatterjee was tried for rape and murder. This was a case of rape and murder, not just a murder. Okay, so he was tried for rape and murder, And the report of a government forensic expert of the state of Kolkata, he reported, yes, the semen was present on the girl's pubic hair. And this semen, being the biological fluid of a male, did not match with Dhananjay. But still, Dhananjay, as per the Supreme Court judgment is concerned, dear participants, he was awarded a death penalty. In spite of having the jurisprudence, in spite of having the criminal theories, it says the case has to be proved beyond the reasonable doubts. In this case, the scientific evidence, which says the semen of this, the semen present on the girl's pubic hair did not match with the Dhananjay, who was the suspect or accused in this case. In spite of the semen not being matched, he was convicted for the death penalty in this case. So this section of 293 is clearly demonstrated in this case, wherein the report of the government experts may be considered as evidence in the court of inquiry. So if that is the case, the question is that does our law limit the use of forensics? It only means that the court has a discretion to consider the forensic reports as a good piece of evidence or not. Section 45 of Indian Evidence Act talks about who is an expert. It says, I mean, the certain Supreme Court judgments also goes on to say a person, even without a degree or a diploma, can be considered as an expert under this provision of Section 45. It only says when the court has to form an opinion upon a point of foreign science or a foreign art. These people who are skilled in that particular foreign science or a foreign art are the experts. However, this Evidence Act was enacted in the year 1872, dear participants. In those days, there was no full-time courses available in the field of forensics, especially in the field of handwriting and fingerprints. But today, we have university-level degrees available for handwriting and fingerprint examinations. But if you ask me if this Section 45 is a relevant provision or a good provision for a handwriting and fingerprint expert, I would say no today, because the things have gone vast beyond the provisions as we had in 1872. We are in 2021, and the provisions and the scope we have today is completely different than what we had in 1872. For this reason, yes, this says a person, even if he is skilled in a foreign science or a foreign art, is to be called as an expert. So for this reason, handwriting and fingerprint experts come under this particular section. But it is essential that today we should have a science degree as a minimum qualification for being a fingerprint expert or as a handwriting expert. High Court of Delhi has also ruled in one of the case that the minimum qualification for the fingerprint experts of the state should be a Bachelor of Science degree. Okay, that is the requirement today. However, the provisions as per section 61, 60, the provisions as per the Evidence Act pertaining to the documentary evidence includes the primary evidence and secondary evidence. So the other sections, which also includes the terms experts, are mentioned in section 69, 70, 71, and 72. But section 73 is very, very important. It says, usually we say in practice, court is the expert of experts. Okay, which means practicing advocates keep using this statement. Court is the expert of experts, which only means that for two reasons. One is under section 293 CRPC, court can rely upon a particular piece of evidence, the forensic reports, or even keep it aside, not to be considered in the particular case of inquiry. That is one option. In addition to this, section 73 gives the court a complete prominence or complete provision that the judge himself can actually decide on the particular signature or a particular fingerprint as available before him. The judge need not even engage an expert in the case. If the case is so prima facie, using the section 73 of Indian Evidence Act, the court can decide if this particular signature or if the signature of this person is of the same source or of the different source. However, Supreme Court in several judgments has mentioned section 73 is to be carefully adopted in the legal inquiry. While the scope is there for judges to adopt section 73, to be carefully applied. So for this carefully applied, the judges usually feel taking the opinions from the experts is a very safety procedure than just commenting about their skill in the given case. Participants, on the screen, I have got a case for you to discuss. The signature on the lower part of the check, which also mentions Maruti Prasad, that is a signature which is known. And on the top, next to the date entry, there is one more signature. In this case, the question was, the top signature was forged after altering the date entry over there. So this was the case which was sent to me from one of the court. And after the examination, I happened to report that the signature on the date entry over there is not forged. Why? Because it's a matter of fact that while you actually are signing, the space available to sign is actually one of the factors which can influence your writing appearance. If you have good space to write, you can write as big as you want. But if you are given small space, especially your examination OMR sheets and your examination sheets, you have to sign in the given space available. So very often, there are people who actually overlap to the next entry also, and you feel very uncomfortable signing in the space provided over there. So for this reason, the signature appears on the top is also genuine signature of the same person. But then question arises, why did this person signed over there? It is because there was a date correction. During 2008, the corrected checks were still a good check for passing. Only these days, no corrections are allowed in the check. But in 2008, it was a good practice for allowing the corrected check also. Look at the screen now. The numeric 8 is what is said to be altered. But the numeric 8 is altered twice. There is one genuine correction where the person made 3 first and then made the 3 as 4, and for that reason he happened to sign attestation. But the receiver of the check in 2008 added the left part of the 8. Only the left part of the 8 is added using the different ink. Please have a check on that. The other part of the 8 has a different ink than the left part of the 8. That means there are 2 corrections, 2 alterations. One is a genuine alteration, one is a fraudulent alteration. And it's a report given by me, also mentioned when the check was given, check was only given for 5,000 and numeric 7 is added later on. The check was not even given for 75,000. This report was surprise for both the parties because my report did not favor either of the parties, because one party claimed signature is forged at the date entry, but another party claimed no, signature is not forged. Check was given for 75,000. So here signature is not forged, but yet check is not given for 75,000. So this case was settled outside the court actually, because the parties did not share the real information to the advocates. So when the report was given, both the advocates were surprised and the court recommended them to settle outside the court. And if you look at the screen now, the check was given. Check was only given for 5,000 and the signing was done. Date was written 30/4/2003. It was made as 4 and signed and given. The receiver's name and 75,000 only was not written. It can be given to the other person, he can write it later on, isn't it? To make the process simple, people would have done this. But the receiver altered the date once again, made the check as 75,000 and wrote the entire name as 75,000 only in the wordings here. Next. Participants, while I understand most of you here does not read this document, which is in vernacular, but let me tell you, even if you don't understand the script here, do you see anything suspicious in this given document? What is suspicious in this given document? Carefully observe and then comment. Is there anything which is suspicious in this?
Sir, the text in this document is abnormally close and it is very closed. There is no breathing space between the words and letters.
So what does that indicate? What do you suspect in this case?
That the person, maybe the mind at that point of time, the person's thinking maybe at that point of time was very clustered and he was confused and he was maybe trying to hide something, but
can there be a possibility where the signature was already available on the document, and just to ensure
and they
that
had
the
to
content,
adjust the text,
right? The
yeah,
content should be before the signature. They have
yes,
just compressed the spacing between the lines. But this suspicious factor is not a conclusive proof the document is forged. While people have commented about the seal, there are different seals in this document, and this is the copy taken from the court record, where the court has put the round seal on the lower part of the documents, but the lower part of the document seal is not a question. That is genuine seal taken from the court. This document was given to me for examination of the signature. While I mentioned in the beginning of my discussion that there are many elements in this case, there are many elements in the document. Signature is just one part of it. Signature, which is in Urdu, was given to me for the examination. This document was given to me as a photocopy. So for examination of photocopy documents, there is no provision as per our legal dictionary. Section 60, the 63 of the Evidence Act talks about the secondary evidences. Secondary evidence is a certified true copies, but not the ordinary photocopies. So for this reason, even if I give a report in this case, it will not be accepted by the court. So I just, while I was examining this case, something stuck in my mind on the document legitimacy. If you observe the seal of this document, you could see the State Huzur Treasury, which is the stamp paper, is usually sold by the State Department, Stamps and Registration Department. From that department, the stamp papers will be sold. And this stamp paper will be first bought by some people called as stamp vendors. These are kind of the wholesalers, right? They actually buy the stamp papers. And if you want a stamp paper, you go buy from the stamp vendors. Stamp vendor bought this paper on 9th June 1974. He has sold this paper to this user on 11th June 1974. 11th June can be a Sunday, Saturday, or any national holiday. But 9th June 1974 can never be a Sunday or a national holiday because it is sold by the State Department. So unfortunately in this case, or fortunately for us, in this case, 9th June 1974 is a Sunday. The stamp paper is said to be sold on a Sunday. In this case, dear participants, I did not give a report of the signature verification. Rather, I applied for a RTI information from the State Department as to give me all the information of the documents transaction happened on Sundays in past 60 years, for which they replied, no transaction has ever happened on any Sunday. So only using the RTI information, this document was nullified before the court. Because when I give a comment, give a report on signature, as I mentioned, one of the most criticized category of evidence. I give a report, objections are raised, cross-examination will be conducted, arguments are made, then the judgments will be heard. So signature can be cross-examined. Effectively, lengthy cross-examinations can be conducted based on signature. But when this is the fact which was given to the court, this cannot be nullified. Remember, this cannot be contested. It's a prima facie evidence that the document is concocted or document is very, very suspicious and it cannot be considered as a genuine document. So with this kind of approach, dear participants, the question before the court about the documents, which includes a lot of elements, paper, ink, contents, rubber stamp, signature, handwriting, everything can be questioned. So the aspect of this discussion is not to limit our view only on the signatures and handwriting in the document, but every element of the document has its own credibility to make the document look genuine or even fraudulent. So with this brief, participants, I'll take up the illustration as given by Professor Naresh sir before our discussion started. However, I was given the time till 11 o'clock, so I aligned my topic of discussion till 11 o'clock. So I'll take up this illustration. The illustration given by sir pertains to the provisions as per the authentication of electronic evidence or the provisions of electronic evidences to be accepted before the court of law. The question before this case is that can the WhatsApp video, which was received by the investigation officer, can be considered as evidence or not? There are two different theories here. One, the investigation officer is supposed to be producing the video as captured by the source device, because there are different judgments. That's what I'm trying to mention here. There are different judgments which mentions about one important evidence in this kind of electronic evidences is that the video which is captured by the source device, that device is to be given for the purpose of examination, and that examination report, the examiner can submit the 65B certificate. That is one provision. The second topic of discussion here is that the person who actually first forwarded that video to the WhatsApp group, because it's a matter of fact that when we actually capture anything on our camera, the clarity is completely different. But the moment you put the camera image on the WhatsApp, the image gets bit reduced. The resolution or the quality of the image or the video will be reduced. In technical terms, as per the Information Technology Act, we have something called as hash value. Hash is the file integrity of the hash is considered as a file integrity value. The moment you send any information, especially the multimedia samples on the WhatsApp, the hash value is affected because the clarity of the sample is affected. So the WhatsApp forwards is not considered as a reliable piece of evidence because the source, when you capture the actual information, the source hash value would be entirely different than what you submit to the WhatsApp. But the question also arises, this is one of the important topic which is not frequently discussed. In this case, if the police investigation officer gets this video, whatever he has received, and submits to a forensic examiner, and we do the authentication of the video authentication. We do authentication to confirm if this video is captured in one go, or if this video is the result of multiple videos being added. See, there's a possibility that I actually click 5 different videos and make it as one single video. And if such video which has been used as evidence in this case is the result of such multiple videos, that can be ascertained by the forensic examination of the video. So the video as it is cannot be considered as an evidence before the court, but in this case, the WhatsApp forwarded video, if it is authenticated by a forensic examiner, okay, and this provision of forensic examiner is defined in section 79A. 79A of Information Technology Act gives a provision for electronic examiner of evidence, examiner of electronic evidence, EEE, examiner of electronic evidence. So this section 79A provision gives the central government the authority to nominate the 79A provision experts. Today, we have got 7 agencies across India who have this title of section 79A experts. So if this video was authenticated by this 7 people in India, any of the 7 people in India, then this video is a good piece of evidence before the court. Otherwise, a mere WhatsApp forward video is not going to be relied upon as evidence before the court of law. So with this, participants, the session is now open for any further discussions and further clarifications. So, sir, Naresh sir, I would request your intervention on the justification given on the illustration what you initially discussed, sir.
Yes, sir. Thank you very much for your elaborate analysis of the problem. I think our students have got the right insight regarding the value of video recorded by someone, and finally it coming to the hands of investigating officer, and he files it along with the charge sheet in a court of law. So that video has to be proved, and you have rightly analyzed it. That it may be a combination of 5 or 6 videos also, it may be forged one, and its quality, its resonance reduces the moment it passes so many devices, and it is not a piece of evidence before court of law. You have rightly discussed Section 79A of Information Technology Act also, and in view of Section 45 of Indian Evidence Act, 293 of CRPC, sir, you have very nicely explained the concept. Thank you very much for your kind analysis. Thank you again, sir. Please go ahead.
Participants, just to add on to this conversation,
Sir.
we all have heard the JNU controversy earlier, Kanaya Kumar's controversy. So you all can relate to this illustration problem very similar to that of the Kanaya Kumar's case, because when the video was released, that Desh Virodhi का जो statements वो लगा रहे थे, that video was different, and for the video a separate audio was inserted and then it was published. It was not the actual video with the actual audio content, but video was showing people are protesting, but the audio was separately inserted and then published in the YouTube. So for this reason, this is a very important illustration what sir gave. Please go back and check with the Kanaya Kumar's JNU controversy case, so you can understand about this concept there.
Thank you so much, sir. Thank you so much. That was really interesting. So as we have come to the end of this session by Mr. Faninder BN sir, it gives me immense pleasure to extend this vote of thanks and express my deepmost gratitude to you, sir. Also, very special thanks to Tanvi ma'am for making this extremely engrossing session possible. And I sincerely hope that the participants found this session interesting and also a very good learning experience. Thank you to all the participants and the faculty members to be a part of this session. A huge thank you to you, sir, and all the best for your future endeavors. Thank you so much. I will now request.
I'll take 1 minute.
Yeah, sure.
I would like Faninder sir to throw some light on this concept, whether white tail of a jet is a document or not. How it can be analyzed.
Yes, sir. Sir, as per the provisions, as per the explanation of a document is concerned, document is something which communicates, which has some information to convey a message to other people. However, the document, as per the explanation of document, I don't think that the white tail of a jet can be considered as a document from my point of view, sir, because it does not go along with the as per the explanation of the document as per our legal dictionary also.
Okay, sir. Thank you.
I would also like to request our head of department, School of Law, Professor Dr. Pallavi Gupta ma'am, to please say a few words.
Thank you, Sambhavi. Yeah, of course, I have listened all the things which Mr. Expert Ali has told about all these things. Really, it is a wonderful lecture, and definitely you have focused on the role of forensic science in the white collar crime, blue collar crime, and cyber law crimes, because we have involved the video on the WhatsApp, Facebook, or something else. So, but I would like to say how the cases of where the drugs are involved. It's a very, very burning topics nowadays. Since forensic science is too much important and too much we can say having the value to solve the cases, then why not all these cases are taking on the priority to solve it? Why this politics involved? Because, when forensic science is that much strong, so it is very easy to solve it. But unfortunately, it is not doing so. But this is the other matter. But definitely, this lecture is wonderful. I think whosoever have attended this session will be benefited. And one request I have with you, Mr. Expert, that can our students do internship under your guidance?
Madam, let me answer both the things. Yes, for your immediate question, we offer internships exclusively for law students on the aspects of forensic science. Your students can take benefit of that. Second thing is that you're asking why forensics is not able to help in a lot of investigation cases. It's a limitation in forensics that we cannot act suo moto.
Yeah.
We keep waiting by the investigation agencies as to what questions they raise. We only can answer that. But however, the advantage of every participant here, while you become an advocate, you become the ultimate investigation officer of any case. Whatever the actual investigation officer did not do before the court of law, you ask the question and get it done. The advocates are the real-time and everlasting investigation officers. When the questions are asked by the advocates rightly, only then the forensic experts can play a role answering those questions. Otherwise, we sitting in our desk, we have a limitation that we cannot ask, so we cannot do anything suo moto. So for this reason, while the forensics has got a good scope, unless and until we are effectively involved in the criminal investigations, the cases actually suffers.
So over to Samraji.
Thank you, ma'am. Thank you, sir. So this is the end of the session, but I would like to request all the participants to kindly switch on your camera for the group photo of the session. All the participants, all the faculty members, ma'am, please switch on your cameras for the group photo. Saurabh, please take the group photograph.
Host is requested to give the option to switch on camera.
So kindly unmute yourself, Faninder sir. Faninder sir, kindly unmute yourself. You are on mute. Yeah. Participants, please switch on your camera. Saurabh, kindly take the group photograph.
Dear students, switch on your camera, please.
So you participants, you've been allowed to switch on your cameras. Please do so. Yes, everyone, please. I hope I'm audible to everyone. Participants, it's a kind request. Please turn on your cameras.
No issue, Sambhavi, you can proceed further.
Okay, I hope the photograph has been taken. Saurabh?
Yeah, I have taken the photo.
Okay, thank you. Thank you, everyone. This is the end of the session. Thank you so much. Thank you so much, sir. Thank you.
विशाल सर, आप लाइव स्टॉप कर दीजिए अब यूट्यूब पे.
Sudhir, sir?
Yes, you can leave Sambhavi. मैं बोलता हूँ फोन करके विशाल सर को मीटिंग एंड करने के लिए. फीडबैक फॉर्म भर दी.
Sir, I actually had something to say if the
Yes.
participants, the remaining participants won't leave.
They can leave ना अपने end. I'm asking to end the meeting to Vishal sir. Vishal sir, are you there?